I'm Christopher Yu, and the founding director of the Center for Technology, Innovation, and Competition, one of the co-sponsoring institutions here. And we are delighted to kick off what we think is a really an important series. I was just talking to Susan before people joined. Um, it's really to meet an unmet need from when I was a student, and all this stuff is often autobiographical, and we all are trying to do our experiences. But I realized at the end of my first year of law school, I had no clear picture of what it meant to be in terms of the career options in the intellectual property and technology law space than I did when I went in. And so we decided to invite distinguished alumni and other practitioners. We're not so snobby that we'll just limit it to alumni. We'll bring in other people too. But we focus on our own because I think that resonates with us and the stories that we have. And so we're delighted to have today, with the support of the Penn Intellectual Property Group, who is co-sponsoring this, to welcome Susan Spaeth to be our first one for this school year. Susan is the Chief Legal Officer of Kilpatrick Townsend. Kilpatrick Townsend is a law firm of more than 600 attorneys around the world, in the offices in the US, Europe, and Asia, that really focuses on areas about intellectual property, litigation, corporate, and transactional matters across a wide range of industries. Susan's practice herself, she served as a managing partner for 6 years, for 2013 to 19. And she's done a wider range of matters in intellectual property, complex litigation, particularly patent litigation, licensing, and counseling. She, most importantly, is a distinguished graduate of the University of Pennsylvania Law School and a tremendous supporter of the school, advising the dean and participating in a number of aspects to really looking at how the role of women and the practice of law and how that has worked, being on our Women's Council. And we are delighted to have her with us to share her journey about how she came from where you are right now as a fairly young law student to being to having the career she has. Susan, I turn it over to you.
Thank you. It's really nice to join you today. I wish we could be in person, but understand I'm talking to you from Half Moon Bay, California. I practice in our Menlo Park office, and but these days I sometimes go into the office, and I often work at home. We are in our kind of most of our senior staff are in our Atlanta office. And so working in from home just means I get to get up at 7 a.m. more often for 7 a.m. meetings to help work through the East Coast, West Coast time zones that we all share. So thank you for the invitation. Thank you for Professor Yu and for all of the people at the Center for Technology, Innovation, and Competition, and for the Penn Law IP Group. The world, as you all know, the world continues to have its economy focus on just the things that you all are thinking about, right? Technology, innovation, competition, and intellectual property, and the intersection of all of those. If you step back and really look at the world economy, almost everything touches it, right? Even in the garment industry, which you don't think garment's not that high tech. It's really, different things are really high tech. And biotech. When I say technology, like you, I'm not really just thinking high tech. I think of all of the technology, and my own career focused a lot on the life sciences part of high technology, which I'll talk about just as some examples as we go. Since we're talking about careers, there's one thing I thought I might start on. Like, when I went to law school, as Professor Yu alluded to, I also didn't have a clue. I was choosing between law school, med school, and PhD programs, and kind of just thought, I think I'll go to law school. And when I went to law school, I did take the copyright, I did take patent law, I did take a licensing class. Back then we did not have the full panoply of offerings that you all can take advantage of in all of your classes. But on the other hand, I did take corporate law. I did take antitrust, right? I did take securities. I did also take, trial advocacy. So a really broad swath of classes that I think helped me, even though I was not an antitrust specialist. There are IP cases that intersect that sometimes have antitrust counterclaims. Sometimes it depends on who's in the White House. Many of my cases, well, let me step back, like I'm a patent litigator through and through, right? But that said, I had a 6-day trial in Chancery Court in Delaware. Not that many patent litigators probably have had a trial in Chancery Court. And I had a 9-week trial in state court out here in Santa Clara County in San Jose, the heart of Silicon Valley. All of those cases that were very technology centric. And the reason that, when I was an associate, I would be asked to be on that team was because of my facility with technology. So even though it wasn't strictly patent litigation, it's always been about different aspects of technology. But going back then, when you go to law school, there's just, you don't know how many types of careers there are in law. At least I didn't. And there are truly, there is a career for everyone. About 7 years in, I'd already had, 3 or 4 trials under my belt. And I was talking to a friend of mine at another firm, and he was talking about his career. We were both patent litigators, both at IP-centric, technology-centric law firms. And his career in patent litigation was lots and lots of Markman briefing and oral arguments on claim construction, right? I think I argued at Markman, a couple of times. My career has been more trial focused, more international patent litigation, more ITC litigation, things where the claim construction is a part of it. Of course, it's always an important part, but a lot more trial work and a lot of different things. These days, of course, both of those things are still true, but a chunk of the people in our patent litigation team focus on IPRs and, patent office proceedings, right? And those are a different kind of proceeding too. Much less discovery, of course, a lot on the papers, much less paperwork, so to speak, whether it's electronic or hard copy paperwork. And so, there's a lot of different careers and career paths, even within, an area that you would think would be specialized patent litigation. There's just so many different areas. So depending on where you see your talents and your interests, just using that as an example, the same thing is true across the board, right? Our trademark team has, I think, over 100 lawyers now, and some of them specialize in obtaining patents. Some of them specialize, we call it, I should say, trademark copyright group takedowns, internet takedowns, protecting people's internet sites and property, enforcement proceedings on people's trademarks, opposition before the trademark office, international trademark protection, right? So again, like even within a field that might sound specialist, the idea is that I think whatever you're, one of the keys to enjoying your life is enjoying your work. And so looking for places where you can really use your talents and fulfill your interests is always a great thing. And before I get too far down the specialty path, I want to make sure I've balanced that, right? You don't want to just only know patents law if you want to be a patent litigator, right? You need to know these other things, because at least half of my cases were part patent law, part licensing dispute, part patent law, part commercial dispute about a supply agreement, where I was going to trial. And I wasn't just going to trial on patent issues, right? And then, at least twice in my life, the night before I would take a witness, the other partner and I would be like, maybe we should switch witnesses, right? Maybe we should just switch and just take the other's witness tomorrow. There were other reasons for that. Both times they turned out perfectly. I'm very organized. So it wasn't like that was a haphazard idea. But, you've got to be facile with enough of the related areas You both want to have some sort of expertise so that over the years, people will want to hire you, but you also need to have enough of related knowledge so that people want to hire you, right? And people want you to be part of the team. You're really contributing to the team in all sorts of different ways. Okay. I do happen to have a technical degree. I have an undergraduate degree in chemistry, a minor in physics, and no surprise, since I already alluded to concerning med school, I took biology courses as well. So, for me, it was great to be a patent litigator because I kind of already had a little start in lots of different technology areas. But for any of you who envisions yourself as a patent litigator, you don't actually need a technical degree. I mean, truth be told, a case a few years ago was on antibody drug conjugate technology. So sure, I knew what a benzene ring is, and I knew, how to look at a little chemical, but that had nothing to do with the technology that, of course, was decades in advanced from when I was in college, right? So it's really the facility with technology and the facility with digesting and then spitting out the technology in a way that, when you're digesting it, talking to the experts, talking to the inventors, or talking to the chief scientists that are going to be your witnesses or helping you out, and really, having them feel comfortable with you, even though, none of us have a degree in exactly what we're litigating, right? So you really can, if you have that facility, if you have that interest, there is nothing, there's nothing you can't do in litigation if you want that. Now, of course, if you want to prosecute patents, you have to be a member of the patent bar, and then the technology degree is much more, of course, it's required to sit for the patent exam, but even those have, expanded, and are taking lots of different technology areas. Before I go back to patent litigation, I just wanted to touch on other aspects of my career, because I think it's important when you think about what you want to do and where you want to end up, whether or not, look, your first job does not mean, your last job, right? And most people are not like me. I have been at the same firm my whole career, but really, when I started, the firm was called Townsend and Townsend. We had 65 lawyers. We had just opened up our third office in Seattle. Our first two were San Francisco and Silicon Valley, Palo Alto. And I joined, and I started doing patent litigation and kind of whatever litigation they came up with. We merged, we acquired two litigation boutique firms along the way. By the time I made partner, I don't know exactly if we had 120, 130, 140 attorneys. And I was managing partner then at Townsend and Townsend and Crew between 2001 and 2007. And we kept growing, right? And then when we merged with Kilpatrick in 2011, that was another chunk. I mean, basically, I've been at a mid-sized firm my entire career. I was at a mid-sized firm when we were 65 lawyers. I was at a mid-sized firm when we were 200 lawyers. And I'm now at a mid-sized firm, even though we have 600 lawyers, right? Because of the way that the law firm, that the legal market and the law firm, how law firms have grown and merged and all of that stuff. But my job hasn't stayed the same. Right? When I was younger, I was thinking about learning my craft. Did I like my craft? Did I like litigation? Did I like taking and defending depositions? Did I like going to court? Did I like figuring out, doing all the sleuthing and organizing with all the facts that inundate you? I did. So I kept doing it. But even as early as a third or fourth year, I started thinking about attorney training. And I was part of our training committee as a fourth year associate and really helped develop our attorney training program. I had other leadership roles as an associate, so that by the time I was elected to our executive committee at the end of my third year as a partner, and was elected to be the managing. We have a firm where we have a chairman and a chair and a managing partner. I was elected managing partner during my 4th year as a partner. So pretty young, right? But back then we were a smaller firm. I was half practicing litigator, half managing partner, really, about 80% time on both. But regardless, there's the leadership aspects. And then I rotated out. We have a system where you rotate out of these kinds of positions. We don't want to get stuck in a rut. So I rotated out, went off the executive committee, 2 years, full-time litigator again. Then the firm asked me to be its first general counsel. And then we merged with Kilpatrick 10 months later, was back on the executive committee, right? And a couple of years later, the bigger firm asked me to be managing partner again. So did another nearly 6-year stint as that. And then the firm asked me to lateral from being managing partner to being the firm's first chief legal officer. So you can probably imagine that over that course of time, my job, what I do every day is nothing, in any given year, it's not like any given year 5 years before, right? And so whether or not you think you might stay for the long run or you don't, I think it's good to give, to give it a shot to really think about what you can learn at the place, what you want from your career, what you want to give to your place of employment, right? In my world, I want training, I want development, I want opportunity, and I also want to give training and development and opportunity, right? Both of those things are what I have found at my firm, and whatever you want from your career, I hope you can, find it at your firm, whatever your company, and really think through kind of all parts of that equation for having a really satisfied career. So as I was thinking about this, like what are the themes? Patent litigation, technology type things have gone through my career, attorney training, attorney development. I'm now leading a leadership development program internal at my firm. So it is a partner leadership development program. So instead of just tapping a partner, midway through their career and saying, hey, we think you'll be a good team leader. Voila, be a team leader. We are now in the first round of leadership training for partners. You're not even eligible to kind of apply or be tapped for it unless you've already been at least a partner for 3 years, right? You kind of got to know how to be a partner before you join this. And frankly, COVID has kind of disrupted our program because we had plans for 3 in-person meetings. We had 1, COVID hit, not in-person meetings, but kind of sub-programs. And we had to shift it around just like you guys, right? We had to decide, hey, was that the person who we were going to have do this aspect of leadership training? Have they done it virtually or not? Have they done, could we really pull off a diversity, equity, and inclusion program by Zoom? Right? Could we get everything we wanted out of that program with this leadership group that way? Yes, but not right away. That meeting was supposed that sub-program was supposed to be March 2020. We canceled it on a dime, and then we only just then rejiggered it and set it at the end of August of this year. But it worked great, and we could take advantage of the fact that somebody in the programs in our Shanghai office and somebody in the program is at our Stockholm office. Now, I had to get up really early, and the person in Shanghai had to stay up really late, but it all worked really well. And we're, both for the participants of the program, and by the way, our senior leadership also participates in this whole program to demonstrate the importance and to get, whatever we can out of it as well. And so that whole attorney training and leadership development part kind of courses through my career. and as well as leadership per se. And then now as chief legal officer, as well as being deputy general counsel kind of along the way. Of course, ethics, professionalism, risk management, security, compliance, right? I'm essentially the lawyer for the law firm now. And so all of those aspects of the area. And so, you know, if you see these, there are aspects of those through lines that in a given year of my career, except maybe my first 6 months, but you know, any given year of the career, different parts of those are a greater or lesser part of my career, but they're all things that I'm interested in. And I just wanted to give that example, right? That it's not like you are doing one thing. You are doing lots of different things in your career, or you can do lots of different things. You know, and there's lots of different opportunities over the course of time to perhaps, you know, where you might want to spend your time that makes having, you know, makes a more fulfilling career. Didn't touch that much on diversity inclusion, but I do spend a chunk of my time on that aspect. And our firm has a really dynamic pro bono program. And so, you know, again, different people are doing different aspects of that. And I do my part in those aspects of it as well, of course, but, you know, it's really the whole of what you're going to do. As one of my good mentors used to say, you know, you spend more hours at work than you do in any other part of your life. And so you really want to make the time that you have at work enjoyable, fulfilling, educational in both directions, you know, along the way. Let's say going back to patent litigation, right? And IP and technology. There, I wanted to touch on just a few more different examples. Some of the things that I have had the most fun with. Well, frankly, going to trial and winning, that's a pretty good thing. You know, there's like not a lot of, I mean, you want to feel an adrenaline rush, you know, having that jury find in your client's favor after, you know, a many year slog fest through discovery. That's a pretty good thing. Winning on summary judgment, again, when, you know, not only are you winning for your client, but chances are you're pretty happy to be beating the pants off of your opposing counsel, right? So all of those things, the competition in me, as well as the client service part of me, those are all great things. More on the daily thing, I didn't have a lot of, you know, going to court for Markman hearing kind of practice. I just never did. I also never really had an appellate practice, although there clearly are people who argue at the federal circuit and other areas as patent litigators. I really had a trial, heavy discovery, and heavy international angle to my practice. The international angle I'll just touch on for about half of my career. A lot of my cases were both US and Europe, mostly US and Europe, once in a while US and Asia. So there would be, let's say, a patent infringement case filed in the US, and then there would be a nullity action in the European Patent Court or in the German court, or there would be patent litigation. My biggest case was in 8 different venues at once. We had 8 different things going on at once. So there was the first case, we were sued, my client was sued in one court, and we filed suit in the Netherlands, and then the next day in Sweden and in Germany. We had a case going on in the International Chamber of Commerce in Paris. And then we had re-exam at the patent office. And then there was a kind of a follow-on district court case in the US, like a different angle. Another one of my cases, we were in US District Court, US ITC, and in Japan. Another case, US, Belgium, UK. Another case, US, Austria, right? So, and why? It's because where are the opponents based? Where is the product being made? Where is the supply coming out? Where can people either, assert pressure, on product supply lines, or take a jurisdictional advantage. So typically in those kind of cross-border disputes, typically either the UK law firm or the US law firm is essentially lead coordinating counsel. In one of those cases, kind of like my first one, the UK firm was that. After that, we were always the lead coordinating counsel. Not that there's anything wrong with the UK law firm. I love them. I think they're great at that. But it just wasn't, the case wasn't in the UK. It was more centered in the US. And so we were the lead. So essentially the lawyers at my firm were the lead coordinating counsel, the lead US litigators, and the US law firm is almost always the lead technical counsel, right? Because you need to make sure that what you're saying across jurisdictions and lots of different languages is can all work together, and you don't take, even though you might be able to take an advantage in another jurisdiction under their particular patent laws or whatever, you don't want it to backfire, right? And get you in a jurisdiction you care more about. And so, so thinking through all those things. And of course, in Europe, many countries still have separate attorney firms and patent firms. And so, you can imagine the number of law firms, right? We would have a patent firm and a law firm in Sweden and in the Netherlands and in Germany. And it was really, and even in the UK, even though in the UK you can, and now in Germany and some other countries, you can have patent attorneys as part of a legal law firm. So, thinking through that, being mindful, these are big budget cases, of course, but you still want to be mindful of the client's budget. And thinking through like all of the strategy and how you're going to play this international strategy it's really fascinating. I mean, I love, these cases I truly, truly love. They were fascinating. I got to travel a lot and all those good things. Once I even got to argue for 6 hours in Belgium, in Brussels. Obviously, I'm not licensed to practice in Brussels, but our court in Belgium, we actually were not in the court we filed in was in Mons, not in Brussels, but we were only the third patent case that that court had ever had. So the court quickly appointed 2 special masters, which were a patent law expert and a technology expert. And essentially in our parlance, the special masters special masters was not their parlance, it's mine, but the way we would talk about them in the US is these were the special masters, neither of which were a judge, right? Who had to undertake the findings of fact. And then they would file a report to the judge, and the judge would make his conclusions of law. Well, because we were not then in a courtroom, and because, that gave, both parties, this was a case where it was in the US and in Belgium and in the UK. So both parties had US counsel and UK and Belgium counsel. So it just evolved that, when it came time to do the arguments, and really it was the US, most of the burden was on the US litigators, burden in a good way. So, one of my favorite days in court, like nobody saw me, right? Except for, one client rep and a bunch of people in Europe, because we were in a conference room in Brussels, and basically for 6 hours just went back and forth on legal issues, European law issues, patent law issues, and all the technology nuances, right? All of the things about the technology and the claims and how we did not infringe, and for all these reasons. So that was a pretty good day. It was just like, you just had to be on your game on all these different aspects. So that was a really good day in my career. Another reason why it was really fun for me is when you're talking to 2 people And they are the patent, they're truly a patent law expert, right? They're a patent attorney and a technology expert. Just that feedback loop that you get with that audience, and there's only two of them, not like a whole jury, which is kind of off to the side when you're directing a witness or cross-examining a witness. It just was a really great opportunity. You could watch them as they're listening to the story, right? As they're listening to how the story is being, discussed over the course of those 6 hours, which of the sides they're gonna, who are they gonna start following? Who are they gonna listen to? Which party are they gonna believe? The same thing happens, of course, with a judge at a bench trial or with oral argument or with a jury. But this was kind of a, all both just a more than an oral argument in front of a judge, but less than a whole trial in front of a jury. And it was just really fun to watch them like, okay, we're just gonna, by the end of the day, they're gonna believe our side, right? We're the ones who are credible. We're the ones who are not afraid of talking about whatever they want to talk about. And we're the ones that are gonna lead them to the path of finding which side to believe, which side to weigh in on. Okay, so I'm pretty sure that I have used up my time and would love to take questions or comments or anything like that. And of course, if any of you want to email me separately about any aspects of this, I'm happy to take questions offline or to give you a ring back as well.
So Susan, thank you very much. If you students who are interested in asking a question, please use the raise hand function, as you are all, I'm sure, very familiar with at this point, the reactions. And while we're waiting for that, we'll ask Gerald Adams in a minute, who's the president of the co-sponsoring organization, the Penn Intellectual Property Group, to ask the first question. But Susan, can you tell us very, very briefly, one cool thing happening in your practice that you're a legal development that you're interested, just to give a sense of what the cutting edge really looks like?
Oh, so that's a great question. And I'm going to actually say on the practice area, I would say more logistics wise, and how not being able to travel is making everybody figure out how to do their oral argument by Zoom or how to do depots by Zoom. A friend of mine is a magistrate judge, and she was telling me that she, in her courtroom, she believes people are better prepared because they know they need everything kind of right at their fingertips. The senior partner can't turn around and say to the paralegal or the junior, the more junior lawyer, hey, what was that? They really have to have it all in one spot. And so she has found that the oral arguments are better. Now, frankly, I can't believe that anybody wouldn't prepare that way anyway, right? From my current practice, because my current practice is more on, as chief legal officer, I would say aspects around privacy and the security, right? So the aspects of technology that relate to security and the interplay of privacy and security, that interplay is really important. That was not so much when I was a patent litigator, but definitely on the technology side, right? Privacy and the different privacy protocols and regulations and statutes that are coming out from different states, and then the security and how that impacts all of us as a business. I'm sure it impacts you guys as a law school, that aspect, security and privacy, those are, if I was starting out, those would also be really good career choices, I would think.
And things that were not on the radar when you started practicing law.
No, right. Completely. I mean, yeah, well, I don't need, I'll age myself, I didn't, you should have seen email when I started out, right? Yeah.
So with that, I will open up to questions. Gerald Adams, I recognize you first, and with our thanks for co-sponsoring this wonderful event.
Yes, thank you. And Susan, we appreciate you joining us on behalf of PIPG and CTIC. for us, it's really an integral part of our club to try and provide a career guidance and trajectory so that students really know what to expect when they get into practice. And I think something that is partially related to what you said, but also embedded as a question is, for us, I think a lot of students come into practice, and the common frustration is we can see the trees, but not necessarily the forest within a litigation life cycle, especially in very complex technologies and industries. And so for us, part one would be, given that Penn has a strong cross-disciplinary curriculum, where should students be looking to understand and recognize those themes? Should it be in antitrust, corporations, obviously the emergence of trade secret law as well in relation to patent law? But secondarily, where can students look to develop the practical skills to be able to start recognizing and understanding these processes going into practice, rather than it being year 4, year 5 as an associate when they're just starting to recognize them?
That is a great question. I will say that there's not a cookie cutter answer, as I'm sure you expected, right? And so having it, I would say, if you want a career in technology, probably, or in some aspects of technology law, I would take a class on licensing and contracts, one of those, because usually there's often something about that, right? It'd be nice to have a little bit of, enough foundation about, antitrust law. I would definitely take a trade secrets class. I don't think I took a trade secret class, but I would now, because you're right, it is a growing aspect of our practice. And when one of the things I run at our law firm is a client seminar that we put on, and it's really patent focused, because we have another seminar that covers trademarks and copyright. But even though the one I run is patent focused, every other year we cover some aspect of licensing, some aspect of trade secrets, some aspect of, on the patent and licensing side, even sometimes bankruptcy. I never took a bankruptcy law class. I don't know that you need to take a bankruptcy class, but knowing that there are certain things that can trigger and impact a license because of a party's bankruptcy is important to know. But you can probably pick up that stuff either later or through the licensing class. I definitely would take licensing and think about trade secret.
So what's fascinating to me is a lot of students think about the law itself, but don't actually think about practicing. And the questions I get from associates right out of the chute is, how do you manage up? How do you manage partners? But what you're also suggesting is thinking about, within the practice, a career, you're going to be eventually, as a partner, developed pressure to develop clients, to try to do that. And the other thing that blows me away is we think smart people just inherently know how to manage people when we don't give you a stitch of training over the 3 years how to run an associate. Given that you actually have been through that as the partner, but a person who thinks about this on behalf of the firm, what kinds of things would you tell a young attorney to keep an eye on, think about, to help them have a successful career?
So that's also a really good question. And it relates to what Gerald asked as well, right? Because I will admit, these words have come out of my mouth to support a candidate for partner. That associate was so great, even though they'd never done this type of project before, they were thinking of what they didn't know, right? They were really stepping back and thinking about what they didn't know in a way that really helped the team. And I slept better because they were on the team, right? I could go to sleep at night because I knew they were worrying about, all the problems they should be worrying about, and helping to think of the problems collectively that we all needed to worry about. So a few things. First of all, this is a really nuts and bolts thing, but if I have a meeting with you, you should not show up without your calendar and a pen and a pad of paper. Now, these days, you can show up with your laptop. It doesn't actually have to be, a pen and paper. You can have fingers on keys instead of, hands on pen, but, and a calendar. Because when I say I expect that you know what your schedule is right then, and you don't have to go back to your office or look at 3 other screens. That we can keep it moving. So let's see. So when you're an associate, let's say you're a litigator and you get added. Oh, the other thing is, it's not like you're an associate and, a client gets sued that day and now you're on a case from day one. No. Or it's not like a client comes to the firm and says, I think I want to sue that company. Can you help draft the complaint? And you just start like from day one at the beginning of a case. I did not write my first complaint until I was a 5th year. Right? I already had two 4-week trials by the time, but I'd never written a complaint. So what you do is you say, if you're a litigator, look at the docket, look at the case management schedule. Like, even if the person doesn't tell you to do so, they should, but you should look at what is the case management schedule and look at what's happening, not just what the assignment is on your plate, but where you are in the arc of the matter. Same thing if you have, a patent that you're in the middle of, whatever is the analogy in your practice. Where are you in the arc of it? And what are the deadlines? And, if there's a deadline in court, imagine that some clients want the draft 7 days in advance. They'll take it 3 days if they have to, if it's a really rush, but otherwise the client needs it 7 days in advance, which means you have to get your draft to the partner or the senior associate or counsel another 7 days in advance, right? So even if they don't tell you, you should be thinking that way, right? Because your best draft is 14, 10 days, whatever it is, right? Your best draft, your final work product, the work product you think is good enough to file in court is due 10, 14 days in advance. It's not due 2 days before it's due, right? So learning to think, in that way. I would find associates who also work with the partners, senior associates, counsel, whoever you're working with, and ask them of their practice style. I know there are people who talk about my practice style, right? Ask the partner or the associate, how do the time, you have to enter your time, right? How does the person enter their time? After I finished being managing partner the first time, I was asked to be on an ITC case because of my earlier International Trade Commission experience. And so essentially I was brought into another partner's client relationship, right? But I was going to provide ITC expertise, but he had the client relationship. He was in charge of validity. I was in charge of non-infringe or infringe. I was in charge of infringement in that case. And one of the associates on the case sent me here's how David likes his time entries. I was not offended by that. I've been managing partner of the firm, right? But it's his client relationship. He wrote his time entries different than mine. I write my time entries and have the people on my teams write in sentences, with a capital letter starting a sentence and a period, and then the next sentence. He would write with semicolons. Right? Usually you write time entries in active voice, but man, if a partner writes in passive voice, then you need to know that, and you need to write your time entries the way they do it. The bill to the client is the most instant client feedback, the way the client interacts with us every month. And so you want that bill to be good. You want that bill to be accurate, of course, accurate, but you want it to all flow together. And so figuring that out. But beyond just talking about what the partner likes and doesn't like, think of, find associates who have been on those kind of cases before and go to lunch with them and talk about their cases and learn, right? So learn, expand your brain so you can think beyond what you know. So you can think beyond what people are asking you. Take the advantage, socialize, and if you're still stuck on Zoom, that doesn't mean that you can't, symbiotically check in with other associates and and essentially have that. You'll probably be assigned a mentor or a buddy or a coach. If that person is in your same practice area, great, ask them. If not, then ask, just ask around. Lots of people will be honored that you're asking for their input, and they won't think it's a burden. So ask them, say you really want to succeed with this partner, or you really want to succeed in this type of case. What would they recommend? And that way they will, when I say case, I don't mean, of course, just litigation, but whatever kind of matters you do, ask for a senior associate's time, because those people know a lot and they can really help you. 2 more things. I'm going to use a patent analogy. Sorry, but I think at least some of you have that. When you look at the patent, you also look at what's called the file wrapper, the prosecution history that's behind the patent. And a lot in litigation can, depending on the case, can turn on what's in that. What is your figuring out your style of organization and memory? Like, I don't expect you to have a photographic memory of what the file wrapper is, but sometimes the file wrappers are 500 pages, right? Or more. I do expect you to have a system so that if I say, hey, wasn't there a 112 paragraph 1 argument in this instance, that you can go back and not have to start at the beginning and reread it again, but say, yes, they talked about that on this and this and these dates, right? So for me, right, remember, I grew up a lot of years before you. I had colored tabs. I still did the whole color code, color highlighting thing from law school, but then if a partner said, what about that? I could immediately flip to it. Now you guys probably are on the computer, but you can tab it, you can annotate it so that when they ask you, it's not that they may not always ask you on the spot, but what partners certainly don't expect is you to start from the beginning and read it again, right? When you read it, you might have to read a file wrapper more than once. I'm not saying that, but when you read it, you need to really read it, and you need to be issue spotting along the way so that, 6 months later, it's annotated and you don't have to start again. You can just kind of familiarize yourself and then go directly to where you need. So if you can think of the analogy of that, right? What is your system? What is your system of organization to make it easier for you? Don't rush the first time, because this is your time to really read it and to integrate it and to issue spot and to have your thoughts. Whether or not it's all for the instant memo, you're going to have to come back to it. The second thing for that is how do you ask questions of people? When I was started out, of course, as I already alluded to, email wasn't much. So it's not like you just have a question and email it, right? I would do my work, and then I would make a list of questions and then go back to the senior associate or to the partner, like with a whole list, but not first of all, it's not efficient for you and how you're going to bill your time. And it's not efficient for the partner and how you want the partner to think about you and their time, right? So, start making your questions as you go through, and then say, okay, can we have 5 minutes? Can we have 30 minutes? I've gotten this far on the research project. You said it would take 20 hours. I'm 3 hours in. Now that I'm into it, I want to make sure that I'm understanding it correctly, right? Those kind of check-ins early, and not, those, kind of having enough thought before you check in and being organized, and also making sure you're under the understanding the assignment once you get into it, those are really key things. And while the billable hour is important, we're not hourly employees, right? So you need to think, okay, you know, maybe I need to read up on this over here to the side for an hour so I can really approach this whole thing. Or maybe I need to talk to somebody for 30 minutes so I can understand the arc of the case, because then I can contribute more. Those kinds of things are invaluable. And usually you can log it to some kind of time, right? It won't be billable, but you can log it to some kind of time at the firm.
Well, thank you. Floor is open. Any other questions from the students? Jesse.
Hi, thank you for sharing your lot of wisdom. Susan, I was just wondering if there are any professional organizations you were mentioning about, like always learning, that you would think would be especially pertinent and especially helpful for law students who want to go into patent litigation.
So if there is an IP in of court, there is in the Bay Area, there is a specific intellectual property in of court. And so that way lawyers can get moot court experience. You know, it's not a whole moot court, but they'll have many arguments, and those are always good practice. And the older members pretend to be the judges, and usually the younger members pretend to be the advocates. And they're not always court. Sometimes they're license negotiations. Sometimes they're counseling sessions with clients, but at least the one out here has moot aspects. That one, I would definitely take trial ad, you know, so I don't know that you'd have to join a moot court now, but, you know, after law school, for sure, if there's one in your area. And if there's not a patent one, okay. If you're a litigator, do the main litigation one you have in whatever area, you know, geographic area you're going to be in. From an IP perspective, out here, the SF, you know, they all have like SF, Bay Area, intellectual, whatever. The AIPLA and versions, AIPLA is the national one, but the, you know, there's local patent law or IP related sessions, and I would check those out too. You know, the first time I went to one, I felt like, oh, if I wanted another job, here are the people who would hire me. I never pulled that trigger, but you know, there's a community of people that will have gone to other law schools or will be a little older or a little younger than you, right? And so you'll develop a set of peers and that go beyond, you know, the people at your firm or the people you went to law school with.
So for what
Great,
it's
thank
worth, there is an IP in a court here in Philadelphia
Okay.
called the Benjamin Franklin American Inn of Court.
Excellent. It's nicer. Ours is SF Bay Area Intellectual Property Inn of Court, right? Like, I like the Benjamin Franklin IP. You guys have a nicer title.
Yes. And there's PIPLA, which is the local version of practitioners in that area.
Okay. Yeah.
Yeah.
So we have SF, a version of that too, right?
Right.
So yes,
Right.
I would do both of those. Now, in the long run, you may decide that you're going to stick with one, you know, depending on if you're a litigator or in a different practice, maybe you'll only stick with one, you know, and then you'll do something else, right? Will you do, you know, a women's group? Will you do a Hispanic law group? You know, like there's different aspects. I would definitely be engaged and then figure out which. You don't want to do 10 things, you know, but you probably want to do a couple.
So we
There's
probably
a Young Lawyers of the Bar Association group. I think that's true nationally. Is that something that's valuable or just depends?
So I don't know. It could be.
Yeah.
I did the IP specific ones and the litigation specific ones. I did not do the Young Lawyers, but that doesn't mean that the Young Lawyers isn't really good. It's just that, you know, I did, you know, kind of the ones that weren't, you know, in the IP space I chose to do.
We probably have time for one more question if there's something from the students. Manish.
Hi, Susan. Thanks for taking the time to talk to us. I saw you also do some licensing and counseling work. So I guess how much of that do you still do? And I guess how does your litigation practice inform your licensing and counseling work and vice versa?
Yeah. All right. So I do it, but in a different way now. Now that I'm CLO, I basically I'll get to what I do, but let me get to more of your your part of your career. When I was so lucky. I consider myself so lucky that in the middle of my first year, maybe the beginning of my second year, one of my clients' strategy to not be sued was to enter into a license negotiation that went on for a year, right? And so I learned to read and think about contracts kind of on a word by word basis. Basically, I think that, when you're in high school, you kind of read for context. In college, you learn to read by paragraph. In law school, you learn to read by sentence. In contracts, you learn to read by word, right? At least that's how it felt to me in my brain. And so I was really fortunate that I did this kind of protected license negotiation, or I was involved. It was only a second year. Obviously, a partner did the partner level work, but I really, that word choice kind of got into my brain. And at the same time, even though I was a litigator, I did do a little bit of patent prosecution. Again, the specific words matter. So that when I was a litigator, if I was in cases, I already mentioned, that were a lot of patent licensing, patent contract disputes, I already had some of that foundation and knew how careful the word by word. And as a litigator, I would do my own settlement agreements. That's not my own by myself, but I wouldn't just hand it off. I would be very involved in the settlement negotiations or in the license that resulted as part of the settlement of a lawsuit, because sometimes lawsuits settle with cross licenses, right? And so I would be involved in that. And so that's part of why I said you need to do license, if you have a licensing class or an agreement class, where you can start learning those things in law school, that'll set you up well. I think that doing some of that makes you a better litigator. Just like I think if you're going to be a hardcore patent attorney, I think if you can do lit support and be on a litigation team as an associate, it'll make you a better patent attorney, right? Because you're going to you learn in both directions. If you're a patent attorney, you'll learn how those litigators, as a patent attorney, you get to spend, 12 grand if you're lucky on an application, right? And then the litigator comes and spends $3 million attacking it, right? So, it'd be nice if you were on one of those teams and could do some technical, patent support on a litigation matter, because you learn things that then you'll bring back to your practice. And the same thing is true with licensing and contract work. If you're a litigator, you're going to train your brain to really think more precisely. Then, as CLO, we haven't touched on the practice of today's, how clients retain firms. It used to just be they'd call you up. Now they want pitches, but now clients not only have billing guidelines, but they have these things called outside counsel guidelines, which have all sorts of areas, and procurement personnel, not always lawyers, not usually lawyers, but people who buy lengths of pipe and toilet paper and nuclear power plants are now involved in the engagement of legal services. And so there are really complicated agreements that our clients give us, or that we are doing an RFP ourselves for the next, whatever, our global real estate firm. And so I do contract and licensing work, but I'm usually approving or reviewing the work of others now in this part of my career.
Thank you.
Well, unfortunately, that's all the time we have. We've reached the end of our hour. It's been really a pleasure to have you back, Susan, and it's an inspiration to see one of our own doing so well. Please join me in virtually thanking Susan for such a stimulating experience and talk. So thank you.